We are live and on the record.
Good afternoon. Welcome to the Appeals Court. I am Justice William Meade. With me are Justices James Milkey and Justice Mary Sullivan will be the panel for this case. Have you argued on Zoom before? Okay, yes, so you know, it's just each side gets 15 minutes. You needn't use all of your time. It's obviously a single issue here in this case. We've read everything. There's no rebuttal. So with that, I'll call the case. It's 2021P 128 Chelmsford School Committee versus the Commonwealth Employment Relations Board and the Chelmsford Federation of Teachers. Ms. Bertrand, you're the moving party, so you go first.
Thank you. Good afternoon, Your Honors. May it please the Court, Jillian Bertrand on behalf of the Commonwealth Employment Relations Board. As you know, the issue before you today is whether a board decision setting aside a unilateral settlement and remanding a prohibited practice complaint for further proceedings is a final order subject to judicial review pursuant to General Law, Chapter 150E, Section 11. And I would submit to you that the board decision, which did not determine the legal rights, duties, or privileges of the parties, is not a final order. And in light of the discretion conferred upon the agency, and in order to preserve judicial resources, I would respectfully request that the court grant the board's motion to dismiss.
Now, counsel, the school committee argues that this is their only opportunity to challenge the agency's overruling the approval of the USO. To what extent do you disagree with that statement? Or to what extent are you arguing that it doesn't matter if that statement is true or not?
Essentially, it doesn't matter. This is not a final order. It is not an adjudicatory proceeding, at least this portion of it. The overarching adjudicatory proceeding is the hearing that took place that will determine whether or not the school committee committed prohibited practices as alleged. This is more akin to a settlement conference. Settlements don't work out all the time. That's common. But the board's decision itself, setting aside the unilateral settlement, is a decision that did not determine the legal rights or duties or privileges of the parties. Essentially, the school committee, though it may not like the decision, has not been ordered to do anything. It has not been found to have violated the law in any way. And so the appropriate thing at this stage is to go forward with hearing. The same would be true, for example, with a motion to dismiss. If a hearing officer granted a motion to dismiss, the adversely affected party can request review of the board. But if the board ultimately reverses the hearing officer's decision to grant the motion to dismiss, the complaint is reinstated and the case goes on to hearing. There's no judicial review at that stage either.
Is that procedure a matter of practice or regulation?
The unilateral settlement procedure?
No, just your we'll get to that in a minute, but just your motion to dismiss example. Is that in your regs?
Motions to dismiss, yeah, there's no, I couldn't say to you the exact reg right this second, but there is no judicial appeal right of a motion to dismiss. That's correct.
And is the settlement procedure in your regs?
The settlement procedure specifically is not in the regulations, but the statute and the DLR's regulations do provide sufficient authority for the DLR to implement such a procedure.
Okay. And when we refer to a unilateral settlement, I just want to make sure I understand the procedural context of this correctly, and I'm not conflating your procedure with that of the NLRB, but I take it that the union was the charging party and the commission determined the complaint would issue?
That's correct.
And did the commission at that juncture then take over prosecution of the case?
No. So that is where the DLR procedures differ from the NLRB. The DLR has no prosecutorial duties with respect to a complaint. So unlike the NLRB, where a complaint is issued and then general counsel prosecutes that complaint, the procedure here is the charging party, when the DLR issues a complaint, the charging party is the party that argues the complaint.
So this is a true unilateral settlement. This is the agency in its administrative and or adjudicatory capacity imposing a settlement.
That's correct.
On the parties. Okay, thank you.
Sure. So I can provide some examples, which I've done a little bit, but examples of final orders subject to review have obviously included a board order reviewing a hearing officer's decision on the merits of a prohibited practice allegation and pre-complaint dismissals. And the logic behind that is that those orders conclusively determine the legal rights, duties, and privileges of the parties with respect to the matter, and they represent the final or the culmination of the board's decision-making process. So at that stage, a violation is either determined to have happened or not happened. That's the end of the process before the DLR and the board and their judicial appeal rights. In contrast, things that have been deemed not to be final orders, as I mentioned, a motion to dismiss, a board decision remanding a pre-complaint dismissal to the investigator to issue a complaint, and unit certification orders. And the difference in each of these scenarios is that the board has not issued or denied an order to desist from prohibited practice, and therefore had not conclusively determined the legal rights and duties or privileges of the parties. Essentially, the board's decision doesn't order anybody to do anything, which is the situation at hand. The board's decision here, setting aside the USO and remanding the complaint, merely determined that the unilateral settlement did not adequately remedy the alleged allegations, but there was no issue, there was no order or denial of an order to desist from a prohibited practice. The legal rights of the parties were not conclusively determined, and it was not the culmination of the board's potential involvement in this dispute.
So say, as I understand it, the hearing has already taken place at this point.
That's correct.
But there's been no order even by the hearing examiner.
That's correct.
Well, let's say the hearing examiner finds a prohibited practice violation and orders a remedy. Therefore, the school committee at that point can appeal. Let's say the administrative procedures are eventually exhausted and there is an appeal back to court. At that point, to what extent, if at all, is the rejection of the USO still a live issue?
It's no longer a live issue. That decision is not part of the adjudicatory proceeding. And frankly, by the time the hearing officer makes a decision and the board reviews it, review, may not even be needed at that point, because theoretically the hearing officer and then the board could find that the school committee committed no violations and is not ordered to do anything. But the underlying validity of the USO is a matter of discretion and not law, and therefore there would be no further appeal of it.
As such, you're saying, and presumably the scope of the relief that was granted could be an issue.
Sure, yes. On appeal, yes. The scope of the remedy, assuming a remedy had been issued, would of course be an appropriate subject on judicial appeal.
There are in more conventional court settings, there are pretrial orders that are subject to argument when the final appeal is made, discovery orders for existence, for example. Why couldn't the school committee argue on appeal that the case never should have gone to hearing before the commission and that the settlement should have been honored? What precludes that?
What precludes that is that this is not, so under General Law, Chapter 11, a decision by the board is subject to judicial appeal if it's a final order. And that in turn refers to, insofar as applicable, General Law, Chapter 30A, the Administrative Procedures Act.
But we've got a final order. Why doesn't that sweep in? Assume we've got a final order. Why doesn't that sweep in the innumerable subsidiary non-final orders that are made in the or rulings that are made in the administrative proceeding?
I'm not sure I understand. Are you saying, once the hearing officer issues a decision on the merits,
yeah,
and
once we
the
have
board,
a final order and an appeal, why can't the school committee argue that the settlement should have been honored in the same way that it could argue that certain evidence should or shouldn't have come in, or that certain discovery orders should or shouldn't have been made?
I mean, the school committee can certainly argue whatever it sees fit to argue, but the fact of the matter is that at that stage, the issue is on the merits. The appropriateness or the scope of the remedy certainly comes into play in that respect. But again, if a settlement agreement falls through, or even more analogous is if a board decision overturns an investigator's pre-complaint dismissal, and the complaint is either issued or in a motion to dismiss setting where the hearing officer has dismissed the complaint and the board reverses and reinstates the complaint, some of those underlying issues are certainly relevant down the line when that case reaches the appeals court. But the fact of the matter is, nothing has been established on the merits yet. Nothing has been determined yet. No legal rights and privileges have been ruled on. And so again, while the scope of the remedy is certainly an appropriate issue before the court, the ability to the board's discretion to reinstate a complaint is just not an appropriate subject for judicial review in any scenario.
Is the answer to Judge Sullivan's question something we need to determine at this point, or is it sufficient for purposes of your motion that there's no current final appealable ruling by the board?
It would be sufficient at this stage that there's no final ruling, and therefore there is no right to judicial appeal at this stage.
So putting aside workers' compensation cases, have you been able to locate any case which has an appellate court reviewing the determination of an administrative agency to settle or not settle a case?
The only cases that I've been able to locate deal with unilateral settlements in the context of the NLRB or the FLRA, and ultimately
Don't FLRA
those
cases have to be reviewed by a judge by statute, though?
Well, the FLRA has a similar procedure in terms of unilateral settlements where they have a prosecutorial role. And so the Supreme Court has found that in terms of a unilateral settlement, while they may be subject to review by their reviewing body, beyond that, there's no judicial review because of the prosecutorial nature of the complaints. And that's the same that the Supreme Court has found for the NLRB cases as well, which, as we've discussed earlier, it's not exactly the same here because the DLR doesn't have that prosecutorial role. So if your honors don't have any further questions, I would again reiterate that where no rights or duties or privileges of the parties have been ruled upon yet, this is not a final order within the meaning of the law, and would respectfully request that the court grant the board's motion.
Is there anything you can tell us about the timing of the hearing examiner's ruling? Did he or she promise it by a certain date?
There's no strict, statutory or regulatory timeframe for decisions to be issued. The DLR does have target timeframes, which from the conclusion of the hearing is about 240 days for a decision. It's generally not that long, but that's the goal, is to issue a decision before that amount of time has passed. But there's no specific, guarantee statutorily or regulatory. And I'm unaware whether the hearing officer specifically promised that a decision would issue within a certain amount of time.
Okay, thank you. Ms. Spartafor.
Good afternoon, Your Honors, and may it please the court. My name is Sarah Spatafor of Murphy, Hesse, Toomey, and Lehane, and I represent the appellant, the CHELMSFORD School Committee. As my sister counsel pointed out, we're here today on a very narrow issue regarding the ability of the appellant to challenge the decision of the CERB setting aside the unilateral settlement agreement. A determination of whether this is a final order is that of a statute, and while I understand the DLR has been tasked with interpreting Chapter 150E, I would argue that the discretion here should be challenged because the duties, privileges, the legal rights, duties, and privileges of the appellant have been impacted by the CERB's decision. In particular, this unilateral settlement agreement, which was signed off on by the executive director of the DLR, required that the appellant enforce or follow the terms of that unilateral settlement agreement, which it did prior to the CERB overturning the dismissal of the complaint in this case. So the CHELMSFORD—
Can I interrupt? In the ordinary administrative law context, an agency remands a decision to a hearing officer is not appealable. And so how is this different?
Your Honor, I would argue that it's different because we're not arguing about the simple remand. We're arguing about the decision of the CERB to set aside a settlement agreement that was agreed upon by its own executive director. When it's a remand of a complaint,
then any party who is dissatisfied with the order to remand or the purpose of the remand in an ordinary administrative context is not entitled to appeal.
Correct, Your Honor, but they would at the time of the final order, right, the end of the adjudicatory process, when you do have that right to appeal, it's the same set of facts and disputes that can then be brought forward to the reviewing court. As my sister counsel pointed out, the issue of whether or not the unilateral settlement agreement was set aside properly or improperly is no longer a live issue and is no longer part of the set of facts that would, at the end of the case, after we receive a decision and then it's appealed to the CERB and then that decision—
Because you could get a favorable decision in the end, can you not?
Of course.
So we have this policy against piecemeal appellate litigation. And so you could prevail in the end and we'd be taking on an unnecessary appeal when it's subsumed in subsidiary issues that can be dealt with when there is a final order.
While I understand certainly the desire to not delve into piecemeal appellate work, this case, we would argue, is distinct in that this is a separate order that is not related to the underlying facts and circumstances of the disagreement between the parties. The substance of the case, whether or not the appellant committed a prohibited practice, was not adjudicated by the CERB in this decision. It was solely focused on its own internal process with regard to these unilateral settlement agreements. And absent a review by an appellate court, by this court, of that process, there will be no review of that process, which would cut against
I don't understand that argument. Let's say this goes to an adjudicatory hearing, and let's say
it did.
Right, but hypothetically, I'm trying to stay out of those weeds. And let's say that you get a decision, and the decision is in part favorable to you, but in part unfavorable. to your client, that is, and that in fact the scope of relief that's granted is greater than that to which your client would have been obligated had the settlement been enforced. Why can your client not then come back to us? You've got a final order in hand, it's appealable, and say, we never should have had to go through this hearing, and we shouldn't have to comply with this relief because the settlement should have been honored at the outset. Why can't you argue that?
I think we certainly could and would make that argument.
I would
but I think the other concern is that at that point, my client will have been forced to endure quite a long adjudicatory process to get to that issue.
That's true of any remand, and our law is pretty black letter on that.
That's correct, Your Honor.
I think what's tough for your client under those circumstances that there will have been factual findings that might then support CERB's position that the settlement was inadequate. I think that's the risk to your client, but that would then be the reality of the case, and you would argue that those factual findings or the relief afforded were either unfounded or overbroad or whatever. But I still would imagine that you might try to argue that the case should have settled. But that brings me to my next question, which is, other than workers' comp, can you think of any other situation under our state law where we as an appeals court review settlements?
To Your Honor's first point, the other scenario in which my client could be prejudiced by not being able to review this at this stage would be if my client does prevail at the end of the adjudicatory process. Because again, our argument is that the CERB's decision was arbitrary and capricious, and that at that point, there'd be no review of that decision. And it would be, again, my client would not have had the ability to seek review of a process that it was a part of due to the encouragement of the executive director. But putting that aside, talking to your second point, I don't believe there are analogous cases under our state law because this is a very unusual process. It is a situation in which there is the ability for these unilateral settlements that by virtue of the term, right, and the process that's associated with them, one party is not going to be happy with or a party to the forced result that the administrative agency is requiring. And then the other party does comply in an effort to resolve the case. And so I don't believe there is something analogous. We would put forward that this is an issue of first impression for this court to review this type of process and whether or not this does fall into the category of a final order that could be reviewed. And Your Honors are correct that this case has proceeded, right? There is no stop in the process at the DLR. I don't believe the parties have submitted briefs yet on the case, so I think we're a ways out from a final hearing officer decision, but that is coming along, certainly.
I can ask a question on that point. Perhaps I should have asked your sister. Was leave sought to proceed with the adjudicatory hearing while this case was pending on appeal?
I don't believe so, Your Honor. I
Yeah,
don't
generally
believe there was
everything stops in ordinary appeal in the court or an administrative agency. In this case, when the case is pending on appeal.
Your Honor, I may be mistaken about that. I apologize. My partner is handling the actual adjudicatory process at the DLR. It may have been that was sought and the parties, the DLR declined to put off the case, and certainly the union wouldn't have been agreeable.
No. I meant leave from this court.
Oh, excuse me, leave from this court. No, leave was not sought from this court, Your Honor.
Now, say you were correct that this appeal could go forward, notwithstanding the arguments about lack of finality. What would that appeal look like, where the kind of decision we're talking about here is about as discretionary as they come in terms of whether or not to approve a settlement?
I think my client has already conceded it would be an arbitrary and capricious standard, which is of course the most discretionary standard accorded to administrative agencies. But we do feel in this case, given that there have been other unilateral settlement agreements that the department has allowed to go forward, which contain very similar terms to what my client agreed to, that it would look like a standard that we would see in a lot of administrative agency appeals, where you're granting a good deal of deference to the administrative agency, but not total deference. And that's where we feel as though there would be a strong case on the merits and a public policy argument that the decision that the CERB issued essentially gutted the ability of a party to enter into a unilateral settlement agreement, because it basically found that unless the parties agree to the outcome, that you need a hearing officer's adjudication of the facts and circumstances for the parties to move forward in a favorable bargaining relationship. And a unilateral settlement agreement by its terms is unilateral. So there doesn't seem to be a situation in which a party could have a unilateral settlement agreement stand CERB's review if the other side is challenging it. This was CERB's first opportunity to review a unilateral settlement agreement. The other 4 that had been entered into were not reviewed, but were approved by the department, of course, who signed off on them. And so it would be looking at a fairly narrow issue, Your Honor, of whether or not how CERB evaluated this unilateral settlement agreement was not arbitrary or capricious. So again, it really doesn't get to the substantive aspects of the case that's currently pending before the DLR. It really doesn't get to them at all. It looks simply at the standards that the CERB used when it evaluated this somewhat new and fairly untested process that they've instituted in an effort to resolve cases before they reach this adjudicatory setting, and in which my client attempted to engage in, and to its detriment, did engage in and follow through on the resolution, and now is being forced to litigate the merits of the case. So again, it wouldn't be looking at the merits. And I think that is another distinctive factor between a remand, right, where we would be looking at the merits, and a case here where you're really looking at the standard of review for the unilateral settlement agreement.
Well, except that apparently the agency thought that the facts alleged and as to which the charge was issued were sufficiently egregious that it should not engage in the unilateral settlement. I mean, it's unilateral as between the parties, but it's bilateral as between the respondent and the administrative agency. And I share Judge Milkey's question, which is, by what authority would we have, or what guidelines would we follow to order an administrative agency to enter into a settlement that it doesn't want to enter into, particularly in a field like this, where we know that the history dating from the passage of the NLRA in the 30s was to tell courts to stay out. Right?
So I certainly understand the concern, but I think the difference in this case is, unlike the NLRA, where it is not a prosecutorial agency, this is a purely adjudicatory agency. And in so doing, I think their decisions should be subject to some level, and are subject to a level of judicial review. And so while I understand the hesitancy to tell an agency to engage in a settlement agreement, that agency did engage in a settlement agreement and then pulled back on the settlement agreement.
No, it had a lower level official who said, I think this should be done in an internal appeal process. And the agency itself said, no, this is not what we're going to do. Frankly, I think the fact that it's not prosecutorial and it's solely adjudicatory makes it harder. And, you know, this is one of those cases where it comes up in a certain configuration today, but the roles could be reversed tomorrow. This is a little bit of a be careful of what you wish for case too, I think. So I don't know, the authority of a court to outside with no 30A review before it to order an adjudicatory agency to stay its hand and settle a case, that's tough for us.
I certainly understand. I think the distinction again is the adjudicatory agency created this process by which it could enter into these settlement agreements, and also knowing that there is a statutory structure by which its orders are subject to judicial review. Now, certainly the board's contesting that this is not a final order, But again, I think that is a subject that is properly before a reviewing court to determine what is a final order. And while certainly that is not, it's a disputed issue, I believe, the appellant believes that this is the end of the road for the discussion with regard to whether or not this USO was properly dismissed in the case. Of course, the result is the case is remanded, but it's really not so much about the result as it is about the underlying merits of the decision regarding the USO. And to your Honor's point earlier about the CERB determining that the facts were egregious, I think it's a bit more nuanced than that, in that the CERB determined that the unusual number of counts in the case and the lack of specificity in the disclosure is what warranted, in combination with the non-admissions clause, which I would point out is something specifically allowed in the underlying guidance from this agency, is what caused it to reverse its prior entrance into that agreement. So again, I do think there's a clear bifurcation between the merits of the underlying case and the review that the appellant is seeking of the standard that was used to evaluate this agreement.
Okay, counsel, please remind me of where exactly we are in the briefing on the merits. Obviously, to the extent we're seriously entertaining the motion filed by the agency, it doesn't make sense for the blue brief to be written and filed. But
my understanding, Your Honor, is the parties are actively engaged in filing their briefs. I don't have in front of me the exact deadline. I believe it's within the next 30 days, and then the case will go over to the hearing officer for adjudication on the merits. And with that, I see my time has expired. I appreciate the opportunity to argue this motion before the court, and the appellant would oppose the board's motion to dismiss this case.
Well, thank you, and thank you both, and especially thanks for joining us on such short notice too. We'll take it under advisement.